Assalamualaikum. My name is Nur Hizwani, Omar, and with me are Azreena Akbar and Nur Farhana Zakariah. So we will be presenting on case review of the case of TY Auto Car Dealer Sendirian Berhad and Tribunal Tuntutan Pengguna and another. Next. Next. So cited as TY Auto Car Dealer Sendirian Berhad and Tribunal Tuntutan Pengguna and another 2020 Malayan Law Journal Unreported 1257. This case was decided in High Court of Kota Kinabalu by Judicial Commissioner Wong Seong Tung in 24 July 2020. So the cause of action is a breach of implied guarantee and unfair contract terms, while the area of law is on implied guarantee and unfair contract terms. Next. So the parties to the case are the applicant, a car dealer. On the other hand, we also have the first respondent, who is the Tribunal for Consumer Claim, while the second respondent is the customer who bought the second-hand car from the applicant. So this is an application for judicial review to the High Court against the decision of the first respondent, who decides in favor of the second respondent in the tribunal claim. Next. Next. So these are the facts of the case. The applicant, a car dealer, publicized a used vehicle, namely Land Rover Defender 110HCPU Puma, in mudah.com website to be sold. So it was stated in the description that the vehicle is in tip-top original condition and that there is no need of repair. Interested in the Land Rover, the second respondent paid the deposit of 5,000 as asked by the applicant, and then he test-driven the vehicle. So satisfied of the Land Rover, the second respondent then paid the full amount of 55,911 and 39 cents and went to take delivery of the Land Rover from the applicant's shop. So to his surprise, the applicant suddenly asked him to sign a delivery order, which was never mentioned before. And among the terms in the delivery order are that the vehicle sold are not returnable, no warranties from TY Auto Car Dealer after the date of delivery, and the vehicle is sold on as is where is basis. So nevertheless, the second respondent still signed the delivery order and he took delivery of the Land Rover. But not long after, the said vehicle developed various problems such as turbo failure, excessive noise, and engine problem, which caused the second respondent to incur expenditures on the repair. Therefore, the second respondent filed a claim against the applicant before the Tribunal for Consumer Claim, which is the first respondent, to claim for the cost incurred on the repair. And the second respondent decided in favor of this second respondent, which they hold that the contract terms were unfair and that the said vehicle is not of acceptable quality. So the first respondent ordered the applicant to pay the second respondent within 14 days the sum of 13,549 and 30 cents. So dissatisfied with the decision of the first respondent, the applicant applied for judicial review to the High Court. Now I pass to Azreena.
Okay, so next I'll be discussing on the legal issues in this case. So the main issue in this case is whether the applicant successfully proved that the tribunal has erred in their decision on the ground of illegality, irrationality, or procedure impropriety in order to quash the decision. So the applicant sought a certiorari in order to quash the decision made by the Tribunal of Consumer Claims, ordering him to pay the second respondent RM 13,549, which was the sum incurred by the second respondent for the repairs of the vehicle he had purchased from the applicant. So the reason the applicant sought a certiorari is because courts are not allowed to interfere with the exercise of power or discretion that has been bestowed on administrative tribunals. So like I mentioned, they can only do this on the grounds of illegality, irrationality, and procedure impropriety. So in order to argue that the tribunal has erred on their decision on the three grounds mentioned above, the applicants raised a few legal issues. The first legal issue was whether Section 14, 2CA, and Section 55 of the Sales of Goods Act, which is an act from England, is applicable and would thereby exclude the implied term which requires the vehicle to be of satisfactory quality under Section 32, subsection 1 of the CPA. So in this case, the applicant had submitted that the tribunal had made an error of law for not relying on the Sales of Goods Act because according to Section 5.2 of the Civil Law Act, they argued that the tribunal made an anisminic error of law by not referring to Section 14, 2CA and Section 55.1 of the SOGA, which is applicable in Sabah and Sarawak, as Section 2(4) of the Sales of Goods Act was supplemental in nature, which proves that the provisions under this act should still be enforced. So, the next legal issue that was brought up was whether the applicant's advertisement is misleading because the vehicle was of unacceptable quality according to Section 32(1) of the CPA. So the respondents were unhappy that the advertisement implied that the car was in tip-top original condition and did not need any repairs, yet many problems were discovered after the respondent had purchased the car from the applicant. The last legal issue is whether the delivery order issued by the applicant was an unfair contract under Section 24(c)(1) of the Consumer Protection Act. So in the delivery order issued by the applicant to the second respondent to sign, the term that read, "The vehicle is sold with no warranties from TY Auto Car Dealer Senior and Berhad after the date of delivery," it provides no room for negotiation, making it an unfair contract because it was in standard form, and it is unfair for the applicant to rely on such a term as it is detrimental to the consumer. So this is because Section 24(c)(1) of the Consumer Protection Act provides that a contractual term will be regarded as procedurally unfair if it results in unjust advantage to the consumer on account of the conduct of the supplier. So next we'll move on to the judgment.
Sorry, Farhana, you're muted.
Sorry. Okay, Assalamualaikum. My name is Nur Farhana Zakariah, and I'll be presenting on the judgment and the ratio decidendi of the High Court. Next. So as Azreena mentioned, the overarching issue requires the applicant to prove any element of illegality, irrationality, or procedural impropriety in order to quash the tribunal's decision. The court held that the applicant had failed to prove any elements of these three, and therefore the tribunal's decisions and awards were upheld. Next. Okay. The second legal issue is whether Section 14, subsection 2C, paragraph A, and Section 55 of SOGA of England, which is the Supply of Goods Act in England, is applicable and would thereby exclude the implied term, which requires a vehicle to be of satisfactory quality under these three sections of SOGA. So the court held that these two sections of SOGA has no application to exclude the implied term, which requires the goods to be of satisfactory quality. I'll first address Section 14, subsection 2C. Section 14, subsection 2C provides that the implied term, which requires the goods to be of satisfactory quality, does not extend to any matter which is already drawn to the attention of the buyer before the contract was made. It is pari materia with Section 32, subsection 3 of the CPA. The applicant contends that they had explained and given the notice to the second respondent that the vehicle was sold on as-is, where-is basis and with no warranties before the second respondent's purchase was completed, and therefore the implied term shouldn't extend to this contract. The applicant relied on the fact that the second respondent signed the delivery order with the no warranty term back in March. However, the contract was actually and in fact concluded when the second respondent paid the balance in February. The delivery order was a subsequent agreement following the conclusion of the principal contract. The terms that the sale was to be on these two terms was only brought to the second respondent's attention in the delivery order, which the second respondent was required to order in order to receive the vehicle that they had already duly paid for. Therefore, it cannot be said that the matter was drawn to the buyer's attention before the contract was made. Next. As for Section 55, subsection 1, this section provides that the right for a contract to be varied allows a contract to be varied by express agreement or by course of dealing between parties. So the applicant argued that although the delivery order was signed after the contract was concluded, the terms of the delivery order has legal effect as it is a contractual document. However, the court referred to a precedent which required the document that the document could be reasonably expected to be a contractual document. This will be explained further in our comment and analysis. In the present case, the delivery order only contained details regarding the vehicle's keys, spare tire, and accessories to be delivered. It was merely a receipt for all the vehicle's accessories. There were no essential terms for the contract of sale of goods, like the price, the deposit, the balance of payments, or even the date of payment. Thus, it cannot be reasonably expected that the delivery order would contain any binding terms and conditions. The contract, therefore, cannot be Section 55, subsection 1 of SOGA are both inapplicable in this case. Next. So this answers the submission by the applicants that the tribunal had made an anisminic error of law by not referring to these two sections of SOGA. So an anisminic error is an error of law by not following or complying with the law applicable, which would render the tribunal to be acting without jurisdiction. The court held that they did not make any anisminic error of law due to the discussion earlier. The applicants failed to persuade the High Court that the two sections are applicable, when in fact they themselves did not follow the provisions under either sections. Next. Now, the second legal issue is whether the vehicle was of unacceptable quality according to Section 32, subsection 1 of the CPA, and that the applicant's advertisement was misleading. So the tribunal took into account of the circumstances established before them, such as the unchallenged evidence of the problems of the vehicle, such as the turbo failure, the excessive noise, the engine problems, as well as the repairs that the second respondent had to make after the vehicle ran kilometers. So in contrast to the advertisement put on muda.com.my, the applicant claimed that the vehicle to be sold was of tip-top original condition and need no repair, implying that the second-hand vehicle was good as new. So the court upheld the tribunal's findings. The court upheld the tribunal's findings that the vehicle was of unacceptable quality and that the advertisement was misleading and unreasonable because especially because the second respondent would have entered into the contract expecting the second-hand vehicle to be good as new. And despite the fact that they were satisfied with the test drive, the second respondent wasn't someone who would know the intricacies and the details of automobiles to realize that there were problems with the vehicle. Next. Now, the last legal issue is whether the delivery order by the applicant was an unfair contract under Section 24, subsection 1, Section 24C, subsection 1 of the CPA. So the court held that it was not unreasonable for the tribunal to hold the imposition of the delivery order to be procedurally unfair against the second respondent. Next. Now, Section 24, subsection 1, 24C, subsection 1 of the CPA provides that a contractual term will be regarded as procedurally unfair if it results in unjust advantage to the consumer on account of the conduct of the supplier. The applicant didn't have any evidence to show that they had given the notice to the second respondent of the terms prior to the completion of the contract, which was made back in February. The court also said that the second respondent was put in a subservient position as they had completed their own part of the purchase and now required the execution of delivery from the applicant. The second respondent was put at a disadvantage for any further negotiations. Otherwise, they would have to resort to litigation, which is unfortunately very time-consuming and troublesome. The court held that the tribunal's findings and the delivery order was an unfair contract as it was standard in form. So thus, this concludes the judgment of the case and reasoning behind the High Court's approval of the tribunal's decision. Now I will pass the floor to Iffah to discuss our comments and analysis.
Thank you, Farhana. Now we will be discussing on the second part of our presentation, which are our comment and analysis based on the discussed case just now. So with regard to acceptable quality in Section 32 Clause 1 of the Consumer Protection Act 1999, we are in agreement that Judicial Commissioner Wong Seong Tung was right in deciding that the vehicle sold was not of acceptable quality. We agree with his reasoning that because the first respondent had taken all the relevant matters and taken into account the unchallenged evidence of the problems in the said vehicle, it was therefore not of acceptable quality. Furthermore, the court refers to Section 32, Clause 1 and Clause 2 of the CPA and mentions that even though the said vehicle is a used one, it must comply with the implied guarantee as to acceptable quality because Section 32, Clause 1 does not confine only to new vehicle. So the court further cited the relevant case, which are Matang Plastic and Daimler Chrysler, and also the case of Euromobile and Nanya Hardware to support his judgment. Thus, we believe that every consumer has the right to claim for the implied guarantee as to acceptable quality, as they have paid accordingly for the items that they have bought. So justice must be upheld to prevent suppliers from taking advantage of the situation by providing unfair contract terms to avoid liability. Next.
Next, I'll be discussing this case in terms of its conformity with description. So we agree with the decision made by Judicial Commissioner Wong Xiaotong when he had agreed with the respondent's findings that the applicant's advertisement in respect of the said vehicle on mudah.com that mentioned the car to be of tip-top original condition and no need for any repairs was misleading. He also said that this claim was not unreasonable as the car needed many repairs after purchase as it had many defects. So by referring to Section 34 of the Consumer Protection Act, where goods are supplied by a description to a consumer, there shall be an implied guarantee that the goods correspond with the description. So in this case, the applicant had claimed that the second-hand vehicle he was selling was in original condition, implying that the car was close to the quality of a brand new car. However, it was not. The second respondent, as a consumer who is protected under the CPA, is entitled to an implied guarantee that the car he had purchased should match the description provided on the website.
So lastly, I will comment on the procedural unfairness based on Section 24C. So Section 24C, Clause 1 of the CPA mentions that a contract is procedurally unfair when it results in unjust advantage to the supplier and unjust disadvantage to the consumer. So therefore, we agree with the finding of the High Court that the applicant was unfair in his delivery order terms. This is because the delivery order made by the applicant was a standard form, which had resulted to the second respondent not being able to negotiate on these unfair terms, which was stated in the delivery order as he had completed the payment of the Land Rover. Hence, the applicant has committed procedural unfairness as stated in Section 24C as the terms were unjust disadvantage on the part of the second respondent. Next.
Okay. Now I will discuss the individual impropriety. Hence, the applicant failed to seek the order of certiorari. So in the case of Matang Plastic and Metalwork Industries and Daimler Chrysler Malaysia, the Court of Appeal held that the implied guarantees in the CPA does apply to a used car, thereby establishing that the CPA does apply to second-hand goods. Now, as I mentioned earlier, the subsequent contract may only vary the original contract when it can be reasonably expected to have any contractual conditions. An example of this was cited in the case of Grogan and Robin Meredith Plant Hire, where a driver's timesheet was signed by an agent of a company. The issue in this case was whether the timesheet could vary a pre-existing contract between the company and would incorporate the new conditions under the timesheet. The Court of Appeal of UK held that it was not incorporated because a timesheet would usually not have any contractual effect, since the purpose of a timesheet is to record a party's performance of an existing obligation under a contract. So this timesheet is purely administrative and cannot be reasonably expected to contain any contractual conditions. Next slide. So this case, this present case that we're discussing right now was first heard in the Tribunal Court of Consumer Claims. In the previous hearing, the court was in favor of the second respondent, which resulted in the applicant to seek a judicial review from the High Court against the decision of the Tribunal Court.
So lastly, I will be discussing on the impact of the decision made by the judge in this case on future cases. So every sale of goods by a supplier must be done in compliance with the CPA 1999 by ensuring that the implied guarantees owed to a consumer are not breached. Secondly, this case reinforces that even second-hand goods have an implied guarantee as to acceptable quality under Section 32(1) of the CPA. And thirdly, future cases will have to analyze subsequent contracts with greater scrutiny to protect consumers from unfair contracts. And lastly, suppliers should be mindful when selling certain goods and should be reminded that every breach of implied guarantee will give the consumer the power to claim for remedies under the Consumer Protection Act 1999. So that's all from us. Thank you.